Lordship, I beg to mention hearing 17.
Yes.
I'm for the state respondent that we have discussed with the other party. This matter will be listed on 23rd of this year.
23rd, as agreed by the learned council for the parties, this matter 23rd.
I beg to mention item number 16.
Yes, Lordship.
I've taken the consent from the other side. Only this matter will be listed after a week.
You are for
The respondent, yes, Lord.
after a week.
Much appreciated.
Lordship, I beg to mention item 18 to 27. Your Lordship,
18 to 27.
these are analogous matters, Your Lordship. This may be listed after 3 weeks, Your Lordship.
3 weeks,
Yes.
as agreed.
Much obliged.
Sir Lordship, I beg to mention item number 5, Lordship.
5.
Lordship, I have received some additional documents to the annex, whom I be allowed 1 week time to file.
By state council for 1 week.
Order number 3, 4,
Yes.
5, and 6.
For number 3 to 6.
After 1
To
week.
file counter, huh? Yes.
Obliged, Lordship.
Lordship, I'd like to mention item number 29. Let the matter be fixed on 30.
As agreed.
Like,
Lordship, I beg to mention item number 8, Lordship.
8.
8, Lordship.
Yes.
On behalf of Muslim Lordship. 2 weeks time granted to file not Monday.
Counter. Yes. Counter. How much?
2 weeks time,
3
Lordship.
weeks.
Lordship. Lordship, I beg to mention item 7, Your Lordship. Here, I've already filed my counter, but the petitioner seems to be an outstation lawyer, and I've yet to serve a copy, Your Lordship. So, it may be discussed with Your Lordship.
Yes. As paid for by the state council, we will later after 2 weeks.
Mr. President.
Lordship, and deeply sorry, in item 29, there's in there.
Entry 29.
Item 29, hearing. Here may be continued.
Hearing may be.
Through VC item number 1, bail hearing from the principal seat.
May I please, Lordship?
Yes.
May I please, Your Lordship?
Yes.
Lordship, 439 application, Lordship. Lordship, allegation is section 370 of IPC, Lordship. Punishment is 5 years, Lordship. Lordship, the accused person was arrested on 16/2/2024, Lordship, and today is 54 days, Lordship.
Yes, Mr. P. What is the status?
My God, we have received the CD, but the CD is last up to date till 18 to 20.
So, Sarsit not yet.
Not yet, my God, sir.
So, let him go.
Almost over, my God.
Almost 154 days, considering period intention. But how will you upload this order? From here, can we upload this order? Huh?
Lordship,
Okay.
Lordship, they are not FIR named accused person, Lordship.
Oh, we are allowing your bill. Don't proceed further.
All right.
To the satisfaction of CGM Kamrup Metro.
Yes, to Lordship.
Same order. Hello. Here it is default bill, not default bill. Earlier was default. It is considering the period of default. This was
Much obliged, sir.
For motion item number 1.
yes, Mr. Sharma. What is this?
This is a bail application. Now, they were charge seated in the month of May 2023, arrested on March 2023, Your Lordship. Under trial prisoners. Now, the section is otherwise 302, but if Your Lordship will see the charge sheet, the very charge sheet would indicate that this was ultimately a group action, wherein the charge sheet would clearly and evidently show that these 3 persons were not involved with the actual killing. there were two locations. One was location C and was location D. Now,
Now
location,
today is listed for the first time.
yes, Lordship. But there are, what I'm praying is, first is the issue of detention, the length of detention. Number two would be the entire proceeding is now stayed, Lordship, because of a suo moto case been going on in the High Court regarding the transfer of the case, jurisdiction transfer of the case. The proceedings is under stay. So on the other hand, on one hand, the proceedings are under stay for almost now 1 year now, and nothing has happened. So if that can be considered, and from the charge sheet on merits, I can show that these three persons were never involved with the actual incident of killing.
Let us have a response on all this from and the status from the.
Otherwise, this bail application is not maintainable because there is no change in circumstances, Your Lordship.
This is a regular bail application.
Yes, Your Lordship.
Earlier
The
rejected.
first bail application was rejected on merit. That is bail application 17 of 2023, Your Lordship. And subsequently, after that, two bail application has been filed.
Rejected by this court.
Yes, Your Lordship. The same accused.
Where
Your
is that?
Lordship, the first bail
I have an
application-
extra, but Lordship, in my humble
Yes,
submission,
yes.
in a regular bail application, every day of detention
No,
would
that-
be a
that-
new cause of action.
no,
This is
that-
applicable in anticipatory bail,
Page 42,
not in a
Your
regular
Lordship.
bail application.
No, that we understand. That is
Yes.
not an issue, but you are a charge-sheeted accused
Charge sheeted accused
under 302.
under
So it
302.
will not be proper to grant today itself
That I
without
understand. That
issuing a notice
that
and
limited.
hearing
That,
the
that,
Your
hearing
Lordship,
the.
that
Your
I
Lordship,
understand.
there is no point of calling for report
No,
right
no,
now,
no,
Your Lordship.
no question
Or
of
the
calling
city,
for
Your
it.
Lordship.
Now, what was the state of the trial originally?
It was not even.
It is yet to proceed
charge-
Your Lordship, because of the stay in that summary
That
petition.
matter, I think we have fixed it
My-
because that will be over by the,
Yes,
because what
yes.
we can understand is in that case, so far relating to the jurisdiction that is determined in Registrar General's case.
Yes.
That is the case, isn't it?
That is the case.
That
Your
is the
Lordship.
case. So that,
So-
that is over. Only thing we fixed it for the response from the informant, whether the informant want to object. That accused
I
want to
think
object.
notices have been issued that so that they can
No,
come.
everybody appeared.
Everybody.
Only we fix this matter, I think next week or something like that.
My
Look,
instruction
here-
is that the matter is still stay order is there and
No, stay order is there, but
Yes.
only thing is that only consideration is
in
to
the
be
verge
done
of
the next
completion
week.
that matter.
Because in that case, only issue to be determined whether it can be transferred or not.
Lordship.
The other issue on which the principal issue regarding jurisdiction, that the customary court and this court that has already been decided, so that view is already there.
So, Your Lordship, the ground taken by the accused in the earlier bail application also, since there is a
No,
stay.
we are issuing a notice here, that's all. You respond to it.
Lordship,
A person has,
What?
do you want me to dismiss this petition today?
Lordship,
I can
because-
allow this on the ground that a person cannot be without the trial for years. Let me pass
No,
this
Your
order.
Lordship, I kindly have a look at this.
See.
Am I remedialist
No,
otherwise?
no, just take your seat. See, principle of law is this.
Lordship.
In a normal procedure, when charge sheet is not filed, the consideration is a different.
Lordship.
And when charge sheet is filed,
Yes,
consideration is different. He is in a back foot because already charge sheet is filed. Will consider on the material available.
Lordship.
This is first consideration.
Lordship.
But another consideration is that non-proceeding of the trial.
Lordship.
A person cannot be continuously put behind bar, maybe for any reason, but not for this delay in trial.
So,
Even we pass judgment where we say that in case of 37 and DPS Act, where
Lordship,
satisfaction is something different. There also we have granted bail on the ground that trial is not proceeding and not for the fault of the accused, but for others' fault.
Lordship.
So therefore, let us examine this matter next week. Either way, we cannot pass an order today because this is listed in motion.
Lordship.
He will also have a right to express his views, and at the same time, we can pass the order either way on the
Yes.
right now.
Yes,
But
Lord.
propriety is not there.
Lordship.
8th of May also.
It took me. This is an application under section so issue notice, so accepts notice on behalf of all the petitioner. As the trial has not proceeded in view of a stay passed by the division bench,
I'll just give the number.
passed in division bench in
Transfer
TR
petition. So,
transfer petition, suo moto 4 of 2023.
4 of 2023, 2383. There is no necessity to call for the scan copies of the record
Yes.
as the scan copies of the record, full stop. Accordingly, list this matter on 8th of
8th
May
of May.
20.
Obliged.
Let us see by that time what.
Yes, Your Lordship.
Because you are also party there. Accused is a party there.
In that proceeding.
In that proceeding. Accused is a party.
Have you appeared?
Yes, so they should praise
No,
that.
somebody
petition.
appeared in
Yes,
that.
yes.
For these accused persons, I do not.
For all the accused, there is someone who has appeared on their behalf.
So you are aware, you appear and express your
Yes,
difficulty.
yes.
Just let it be heard earliest because I am inside.
Yes. Obliged, Your Lordship.
Item number 2.
Please, your lordship. Lordship, on behalf of my learned friend K. Angami,
Okay.
lordship, may I pray this matter be listed after 2 weeks.
Okay. Okay. Under prayer of the learned council, state council, matter stands adjourned and be listed after 2 weeks.
I'm obliged. Lordship.
Item number 3.
Yes.
Please, my lord.
Yes.
Just allow me to briefly give an overview of the factual background, lordship. This criminal petition arises out of a criminal complaint case filed by the respondent number 2 herein, lordship, alleging that by some statements and pleadings in a writ petition pending before this honorable court that we have defamed her, lordship. That is the issue at hand, lordship. So, lordship, the subject matter, allow me to just for clarity, the subject matter of the writ petition that is pending before this honorable court is that, my lord, the petitioners have challenged the appointment, or in other words, the executive action of the state respondents in appointing the respondent number 2 and 30 others, and on the basis of an RTI.
Where is the complaint petition?
The complaint petition, my lord, is
Yes.
I've also annexed it. It will be,
The complaint petition was not annexed in this petition.
yes.
Instead, records were called for.
How will you decide?
No, lordship, I have annexed the petition in my complaint petition, but then the records have been called, lordship.
See, fundamental issue is this: when you file a complaint
Yes, lordship.
and you seek an quashing of that complaint,
Yes, lordship.
how can this petition be entertained without a complaint?
Lordship, page 14, I have annexed.
Huh?
Page 14, annexure A. And the relevant, lordship,
Yes, 14.
yes, lordship. Relevant page is at page number 24. The paragraphs which they are saying that we.
20?
24.
Space.
Page 24, lordship.
Yes, space 24.
Yes, lordship. This is the,
On what basis? Tell us what is the law as regards 482. Forget about your facts. When can we quash and complain on the basis in exercise of power under 482? What is the necessary ingredients?
lordship, if the essential ingredients of that offense is not.
Not
there,
made
first of
out.
all, that is
How
not made out.
do we know that essential ingredients are not made out?
So, my lord, in a,
How do you know? Tell us. Forget about your case.
yes, lordship. In a criminal complaint, it is
Huh.
not this criminal complaint is not based on an FIR, lordship. So the criminal complaint itself has all the required.
Therefore, we'll have to,
On
the
the-
principle of law under 482 is,
Yes, lordship.
if we go by the complaint
Yes, lordship.
and take it to be correct
Yes, lordship.
and no case is made out. Now, how do you know that case is not made out without reading the complaint? Is it the duty of the court to call for the case there? We may not even call for the case there.
Yes, Lordship.
We cannot case for the complaint case. What is the necessity of calling the complaint case? What we need to go through is the complaint and the statement recorded for evidence before search.
But
If no case is made out, no case is made out.
Lordship, the statement here, if we can go through the statement.
Why should we? Is it only on that statement? Do we not require the whole of the scheme? What are the statements?
Lordship, I think if we can go through the statement, it will be very clear that there's no case.
You say that these are the only statements? We need not read the complaint.
So we will, Lordship, the complaint is here. We can also read the entire complaint also, Lordship.
That is the most
My Lord's
essential thing.
Yes, Lordship.
Because it says after reading of the complaint or FIR, and if it is taken to be correct,
Lordship.
then no case is made out.
Yes, Lordship.
You will quote some paragraphs of that complaint and the whole proceeding is dead.
My Lord, they quoted some paragraph of the writ petition and saying that is an amputation.
That is your story.
No, Lordship.
Your story.
The record is
We will not see to the record. Is it the way to call for the records of a case on mayor asking? Need we not have the satisfaction that this is the complaint, no case is made out? Is it the way to file a petition under 480 to install a proceeding? We will not entertain this petition. This is not the way to quote and say that this is the only question.
I leave it to you, Lordship, but Lordship, just allow me to make my case, Lordship. Record is there? Yes, sir.
Yes, are you going for final disposal?
If your lordship desires to take it up, then we can take it up.
We do not know. Let us see. But we are not happy. We cannot entertain this petition in absence of the complaint. This is not the way to file a 482 petition.
My apologies.
No, it's not your apology. You should file an affidavit and bring the complaint on record. The present petition is filed under section 482 for quashing, 482 CRPC for quashing the criminal complaint case number 1 of 2023 on the ground that no case is made out under section
499, 499.
499 IPC in IPC. To ascertain such facts, this court is to go through the complaint petition, which is not even a part of the present writ petition, present 482 petition. In view of the aforesaid, let the learned counsel for the petitioner bring on record by filing an affidavit the aforesaid criminal petition. List this matter when?
After 3 weeks, Lordship.
After 3 weeks.
Item number 4.
This is otherwise a contempt matter. Now, it is fixed today for compliance. So,
yes, what is the...
My limited instructions is that this is basically for release of a compensation money. Instruction is that there has been some release or some writings on paper for release, but actual payments have not come. So, if it can be fixed after some... By that time, I think the picture will be clear.
Otherwise,
8th of
Your
May-
Lordship, as directed by this Honorable Court, order dated 29 February 2024.
Where is that order?
29 February 2024.
Okay.
The state respondents have directed Deputy Commissioner Pack to release the money.
He is also a state respondent only, Deputy Commissioner Peck.
Why this is here?
Single bench. Our High Court rules provides that even if an order is passed by a division bench, contempt will lie before a single judge.
Then why contempt petitions are listed before division bench always?
In the principal bench, again, the law is a bit different. I have checked that. While filing also, I had this difficulty. Appendix 7 or something, I just don't remember, but it is there. In the principal bench, it can come up there, but in outlying benches, single judges can take up the matter. Also, you can have it on 8th of May. I think by that time, proper compliances will be on record.
Okay, so what was the direction in PIL?
PIL was for release of the money within 6 months.
Okay.
So that 6 months was over and then the money has come.
List this matter on 8th of May.
Yes, sir.
As agreed to by the learned counsel.
Obliged, Your Lordship.
Item number 6.
Yeah, please, Lordship.
Yes.
Lordship, here, I'm not a state respondent. I am here to receive instruction, Lordship. So, Lordship, may please to grant another 2 weeks to file affidavit in Lordship.
Now, what about the other respondents?
May I please, Lordship? Lordship, I'm for 6 to 14. Private respondent. I already filed my affidavit.
You have already filed?
Lordship.
Okay. All private respondents filed their affidavit?
Yes, sir.
Yes. Though the private respondents filed their affidavit, counter affidavit, the state is yet to file counter full stop. The state council submits that he is yet to receive instruction.
Lordship.
And seeks for
3 weeks time.
3 weeks time to complete his instruction and file the counter affidavit.
Lordship.
Prayer is allowed, list accordingly.
Yes.
Item number 9.
May I please, Lordship? Lordship, on previous occasion, we were allowed to serve Dusty upon respondent number 2.
Okay.
We have served the Dusty, but we are yet to receive the received copy from our client.
Okay. The learned counsel for the petitioner submits that though service upon respondent number 2 through Dusty has been effected, however, he will require 2 weeks time to file affidavit in proof thereof. Prayer is allowed, list this matter after please.
Lordship, there is an
interim order, pass earlier shall continue till the next date of listing.
Obliged.
Item number 10.
Yes, Lordship. Yes. Instruction to appear on the
Yeah, instruction?
Yes,
Okay.
That's
Lordship,
good.
my sincere apology in the last occasion, Lordship. There was some miscommunication regarding the order, Lordship.
Okay,
There were two orders
okay,
passed on the same case, Lordship.
okay.
So the communication was going on between the government advocate and the department, Lordship. And we received the clarification from the government advocate.
That's why we have not, we have fixed it today.
Lordship.
See, sometimes it happens. That's why we have not taken the extreme steps.
Lordship, my sincere apology. For
That's
that.
why we have recorded that whether we'll have to affirm
Yes.
whether.
And Lordship, in fact, the case of the petition is under consideration, Lordship.
Okay.
We have written to the.
So you file an affidavit in that regard, in the meantime, there may be compliance. Okay.
Yes, Lordship. Now we have sought for the
Okay.
attendance of the petitioner.
Okay. You are Mr.
N. Mozoi.
N. Mozoi, Learned Counsel, has entered appearance on behalf of the respondents.
Lordship.
Full stop. He has further submitted that the case of the petitioner is under consideration and the petitioner has already been asked to appear before the competent authorities.
No, Lordship, we have written to the.
Okay, you then keep it there.
Lordship.
Keep it there. Be that as it may, as the respondent has entered appearance, let them file an affidavit if so advised.
Lordship.
If so advised by the next date fixed.
Lordship.
Is this matter after
2 weeks, Lordship.
you say?
3 weeks, it is Lordship, because we have to communicate to the
Okay,
MC about the Mambo.
Let it be after 4 weeks.
4 weeks.
So since they are in the process, maybe by the next time, instead of filing affidavit, they can come and say that we have complied.
the order.
Okay, after 4 weeks.
Lordship, much obliged.
Registry to reflect the name of the learned counsel in the cause list. Currently for respondents in the cause list.
Item number 11.
May I please, Lordship?
Yes.
Lordship, I received a counter affidavit filed by the state respondent this morning. So I mean,
Learned counsel for the petitioner submits that he may be granted
2 weeks.
2 weeks time to
And Lordship,
2 weeks time to file reply affidavit.
and Lordship, with regard to private respondent, that is respondent number 6, we have taken steps on 6/10/2023.
Full stop. Prayer is allowed. Await service report in respect of respondent number 6.
Item number 12.
Mr. Chair.
Yes.
Lordship, here I have received the counter file by respondent number 1, 2, and 3. So if I may be allowed 3 weeks time to file my reply, Your Lordship.
Okay. And what about 9 respondent? Await.
Still awaited, Your Lordship.
Still await service report. Agot was 6 na? Same order, reply and await service report in respect of respondent.
Lordship, my presence may kindly be reflected.
Okay.
I am appearing for respondents 1, 2, and 3.
1, 2 and 3. Just record. You are Mr.
Santiago.
Santiago. Huh?
In the cost list, it's
Cause it is Santiago.
Item number 13.
Lordship, here I have sent the counter affidavit for approval to the authority, Lordship. Here also I am appearing for respondents 1, 2, and 3.
Santiago, learned counsel for the respondent number
1, 2, and 3.
1, 2 and 3.
I may
Submit.
kindly be granted 2 weeks to file my affidavit in reply. Affidavit in opposition.
Praise for and is granted 2 weeks time to file affidavit in opposition.
Lordship, here also service report on respondent number 9 is still
Respondent
awaited.
number 9. Yes.
Item number 14.
Lordship, here also I have sent my affidavit in opposition
Same
for approval.
and
It may
respondent
kindly be
await
listed after 3 weeks.
Santiago, 3 weeks and await service report in respect to
Lordship,
respondent number 9.
here there is no respondent number 9. There are only 8 respondents, so notice is complete, Lordship.
Then why this is maybe written?
Lordship, I'm also not
This
sure why is
updated
it.
that service is complete.
Yes, Lordship. My pleasure, Lordship.
Item number 15.
Same order, Lordship.
Same order.
Yes.
Yes, Lordship.
I have sent for approval. It may kindly be listed after 3 weeks.
3 weeks.
Service report on R9 is still
9
awaited.
R9 service R9. In the case previous, there is no respondent. Others I have.
Much obliged, Lordship.
Deeply obliged.
Supplementary clause, please. For motion item number 1. Where is the here?
Correction so pertains to the petitioner's father's name.
Name. Where is that? Where it appeared?
The first one, it appears at page 20. Page 20.
Page 20. Just give me the details of which I'll just mark it. Page.
There will be page 20, clause 6.
Page 20, paragraph 6.
6.
Apni sahi logo. Page 3, subpara 6. Private quarter. Where is that private quarter?
Yes, Kaiko Mau.
Kahiko Mau should be.
Just Kaiko Mau. That's it. He's not the father of the petitioner.
Okay, it is a private quarter. Okay.
Yes.
This father of the present petitioner should be deleted.
Yes.
Okay.
And the second is at paragraph 15 of the judgment.
Paragraph
appears at page 27 of this petition.
Page 27. 27. Paragraph 15.
The notice, admittedly, the notice was issued to the father of the petitioners. It's not issued to the father of the petitioners. It was issued to one Jaiman Koma, which we do not know.
Issued to the father of the petitioners. Huh? That much?
Yes, and yes, only those two. So as to paragraph 15, I'll leave it to your lordship as to how to correct this statement. Because the notice was issued to one Jaiman Koma, who is not the father of the petition.
And what about the father of the petitioner was not patta holder? That is correct?
That is also not correct. That statement, the first statement. Over and above those does not require any correction. Only that first statement.
Father of the petitioner was not even a patta holder.
No.
That is correct. That fact is correct.
That fact
will not change anything.
Yes, yes.
So you leaked there is a typographical error as regard mentioning the name of the petitioner as Kaiko Mau. Isn't that it?
Yes.
Your father's name is not Kaiko Mau.
No.
Kaiko Mau. Father of the petitioner. Okay. Such typographical error occurred at line 1, 2, 3, 4 of paragraph 3 within bracket 6. And then where is the other?
At paragraph 15.
At paragraph 15.
Yes.
That much only. First is at paragraph 3, 6, and other is paragraph 15.
That's it.
No, not okay. Full stop. Peruse the material and also read the judgment. Full stop. Read the judgment. The writ petition was allowed for wrong for comma. And in the writ petition, an action under what was the act? What is the name of the act?
Eviction of persons from unauthorized occupation act. Or in short, the act of 1970.
Eviction of unauthorized occupants. Where have we put in this act name? Now, name of that. Give the name.
Yes, I'll provide.
Act. Act 1971. Okay, Act 1971. 1971. Full stop. 1971. Full stop. And therefore, in the context of the judgment, the mentioning of the name at paragraph, at line 1, 2, 3, 4, 5, 6, more particularly the more particularly the sentence within the sentence bracketed sentence within bracketed sentence more particularly the father of the present petitioner, okay, is required to be deleted. Accordingly, it is provided that the paragraph 6, paragraph 3 within bracket 6 shall be read as follows. The waste by private quarter of Kaiko Mau. Full stop. Okay, that's all. Then the father of the present petitioner will go. I have just go through this page 20. At paragraph 13, at paragraph 15, instead of within inverted comma, what is the name of comma? Notice was issued to that Mao, is not it?
Yes.
It was written that admittedly the notice was issued to the father of the petitioner, and the father of the petitioner was not patta holder. Okay. The said line, in the said line, it should be, it ought to have been, in the case in hand, comma, admittedly, the notice was issued to Mr. Kaiko Mau.
Simon Komau.
Simon Komau. Simon Kau. And petitioner's father was not even patta holder. That is fact, because that was notice was the plan against which notice was issued. Your father was not the patta holder. That is correct. That is correct. And notice was issued to that Kaiko Samaiko Mau. So therefore, there is a confusion whether Samaiko Mau is your father. That is the defect. Because of this name character, that was a mistypography. That's why I'm saying it's a fundamental decision is not sense. Yes. So the father of the issued to CHA MAIN KHO
Mau MAO
KAIKHO Kaiko.
No, that's Jamaiko Mau.
No, forget about the Samaiko, last word.
Kaiko. No.
Last word, just spell it.
Jamaiko or Kaiko? Those are two different persons.
Those are two different persons. Okay, Samaiko Mau. Instead of the father of the petitioner. Accordingly, the paragraph 15 be read first part of the paragraph 15 be read as follows. Just delete issued to the father of the petitioner instead of that issued to Samaiko Mao. With the aforesaid, the IS stands allowed. Khaliji Dishile, read petition should be read. This order should be read along with the judgment and order disposed of.
For hearing, item number 28.
Yes.
May I please, Your Lordship? My Lord, this is a petition bringing by the petitioner for compassionate appointment.
Okay.
Your Lordship, the husband of the petitioner died in harness in 2021. There's a scheme issued by the state government where spouse, children, and sons and daughters are eligible. Your Lordship, the scheme is at Annexure 4, page 14, Your Lordship.
Yes, 14.
Page 14.
Okay.
Your Lordship may kindly go through number
Clause?
6.
Clause 6.
Clause 6, Your Lordship.
The scheme will be available. Isn't it?
Yes.
Okay. Okay, now.
So I'm praying for compassionate appointment. I am the wife of the deceased employee, Your Lordship. So I'm praying for compassionate appointment.
Now, what is the stand of the government?
Lordship.
Where is your application? Have you filed any application?
Representation, Your Lordship.
Huh?
Yes, my representation.
Your representation or any form? You consider her case.
Lordship, if Lordship may kindly come to page 14 of the writ petition, Lordship. Under this scheme, it has also clearly stated that Lordship that appointment on compassionate grounds, Lordship, it shall be made only on regular basis, Lordship. And the petitioner's husband, Lordship, when he was initially appointed, he was on temporary basis, Lordship.
Then
his service was not regularized, Lordship. So
you reject her claim. Where is that rejection? We are not the authority to decide so that she can come and say that this is right or wrong. She claims a compassionate appointment under the scheme of 2015. Okay. Her employer should say, no, your husband was not regular, therefore you are not entitled. It is rejected. Why should she come to the High Court for that? So you consider her case and decide in terms of, we are not saying anything.
Lordship,
or if you want to file an affidavit to that, because that is not on record, where is your affidavit?
Lordship, I have filed my counter, Lordship.
Yes.
If Lordship may kindly come to page 2, paragraph 2, Lordship. I have stated there, Lordship.
You have stated?
Lordship. Page 2, Lordship, paragraph 2.
Page 2, paragraph 2.
Lordship, on my counter affidavit, Lordship. I filed 2 affidavit, Lordship.
Affidavit in opposition on behalf of state respondents. Okay. Paragraph 2.
That with regard to the statements made in paragraph 4.
No, this is something different. By an affidavit by Srimurti Livitoli Sukulu, Deputy Secretary. Is that it?
No, Lordship. My counter affidavit, Lordship.
Counter, yeah. We have found a counter affidavit to the affidavit in reply.
Filed by the petitioner.
Okay. Okay. This I have found 11th May. This is by Lilavati Sukhalu, that is in the record. Okay, you want to say this by Weku Jimei. Yes, that as okay, read it.
That regards to the statements made in paragraphs 4 and 6 of the affidavit in reply filed by the petitioner, the answering pertinent states that Rule 3 of the OM dated 13/2/2002 and Rule 9 of the OM dated 17/9/2015 have specifically stated that compassionate appointment under the scheme, irrespective of appointing authority, specified under rules shall be made only with the approval of the respective HODs with prior clearance of the PNAR department. Since the compassionate appointment of late I. Otimaran has no record reference to the clearance issued by the PNAR department, it is evident that the prescribed OM procedure was not followed. The petitioner may be receiving the family pension, but as stated above, the ex post facto clearance of PNR department in the case of late I. Otimaran is a necessity to enable the petitioner to pursue for compassionate appointment as per the laid down procedure, Lordship.
So this is a presumption. You do whatever necessary. It is a presumption that since PNR department clearance is not there, so therefore might be she not cannot be granted. So she says that she's been granted pension.
Yes,
Family pension.
Yes,
So
Your
therefore you are
Lordship.
according
I'm
to
a regular employee, Your Lordship. And I've served more than 14 years before the demise of the petitioner. He has served more than 14 years. If at all there was some mistakes or correction has to be done, they could have done at that point of time. At this stage, they cannot come and say my appointment was irregular. I have not gone through the process because I was appointed by the state government as a regular employee against a vacant post.
But Lordship, in the writ petitions also, they have also already stated that it was on a temporary basis, Lordship.
But how she is getting pension?
Yes, Your Lordship, I'm getting full pension.
That is not a dispute in your affidavit also. A casual employee will not get family pension.
Yes.
So if it's a regular, if it's a from procedural lapses are there, what to do? Tell us.
Lordship, then kindly grant me a short date.
Okay.
So I'll
okay, we'll just record it so that in the next date there is no confusion. Hard.
Your Lordship, enough affidavit has been filed.
No, we'll just clarify one thing. No, we cannot issue a direction for appointment.
If
Okay.
because
See, listen to me.
Yes.
We cannot direct an appointment
Yes,
under
yes,
compulsion. This is what we can say is that consider her case in terms of the OM and pass a speaking order. Then in the speaking order, they will have to say all this.
Yes, Lord.
Is that we can do?
Yes.
Pass a speaking order. Or what we can do is we'll have to clarify, we get a clarification from them because in the affidavit, they have admitted that you are getting pension.
Yes.
And they are saying that you are not entitled for any other scheme, but for want of PNAR department some approval. Okay. So we'll put a question to them today. If a person is getting pension, except an regular employee, there is no scope for a pension. And you also claim that your service was a perma against the regular, you are regularized or something like that, government employee.
I'm a complaint.
Government employee.
And for that,
So therefore, let them make a clarification that as regards this clearance of PNRD, and this is only a presumption. This is only a presumption. Isn't it? Or we dispose it of to consider. Huh?
Lordship, short date.
Okay,
So that I
short,
can get
okay.
the instructions, Lordship.
Okay. The present petition, let's listen to me. Present petition is filed seeking compassionate appointment, seeking appointment under the scheme of compassionate appointment of the state of Nagaland, more particularly in terms of office memorandum dated 17th of September 2015. It is the case of the petitioner that the respondent employer has not considered her case for compassionate appointment. The state has filed an affidavit and their fundamental objection is that the compassionate appointment under the scheme in question shall be made only with the approval of respectives capital AHODS with prior clearance of P&AR department. However, the compassionate appointment is in respect of the petitioner, no record or reference of clearance issued by PNAR department is available, and therefore it seems that procedure for clearance by PNAR department has not been followed. That being the position, let the respondent clarify whether it is the petitioner who is to get such procedural clarification by herself, or it is the employer who is responsible to follow such procedure. And if it is the employer who need to clear such procedure for appointment, and on why in the case of the petitioner such procedure is not followed, in as much as the affidavit filed by the undersecretary dated 18th of March 2024 reflects a presumption in this regard only. Accordingly, list this matter on
After 2 weeks, Lordship.
after 2 weeks. In the meantime, the Learned State Council shall obtain instruction as discussed here in above. List this matter after 2 weeks. Then it will be clear. If they say it was our responsibility, then we'll ask them, okay, follow the procedure. If she's entitled, if not, is not. Because only procedure will not be the ground. There will be some other grounds also. There must be vacancy, there must be preferences, all these are there. Okay.
Can you vote? And then what about this item number 28? And then you have to hearing, this one, we got the names. Discussing the volume.